Born in Angola in 1967, Mr. Serpa Soares holds a degree from the Faculty of Law of the University of Lisbon, where he also served as a lecturer, and a diploma in European Juridical Studies from the Collège d'Europe in Bruges. We are extremely pleased to have you here. We're going to begin the program by engaging in conversation for 30 or 40 minutes, and then we will turn to our audience for their questions. So to begin, I thought perhaps the most appropriate place to start is by asking you to describe your role at the United Nations, and the relationship of your office with the Secretary General and the other UN offices and agencies.
Very good. It's a good start for our conversation that we will try to keep dynamic and not too formal. Now, my legal role as advisor to the Secretary General, it would be roughly the equivalent of the legal advisor in the State Department, or what I did before, but at the United Nations dimension. So we serve as a legal advisor to the Secretary General, but the Office of Legal Affairs also serves as a support service to all the principal organs of the United Nations, to a certain extent on a more informal basis to member states, if needed. Like any other position in the foreign affairs, I work in a very political environment, and that brings, of course, specific challenges. And it's up to us legal advisors to make a bigger room for law within the political decision-making process. And we need to make our political masters understand that law is also a diplomatic tool. It's very much part of the political discussions, and we need to convey that and to make ourselves part of the political process in a helpful way. And I was this morning on the train here discussing with one of my collaborators that the Office of Legal Affairs, which I just founded 2 days ago. The Office of Legal Affairs is going to be 70 years on the 13th of February, so next Saturday. And it's very curious that on the first General Assembly, member states felt the need of creating an Office of Legal Affairs. It was created in 1946. I think it's probably the oldest office in the Secretariat, which is interesting, isn't it? Because many often, when I was a student in law school, I heard so many times that international law is not really law, and I still listen to that comment. And we were at Georgetown University over lunchtime to have a meeting with students. It was one of the questions that So we're still international lawyers. We still have to explain nowadays that international law is law, we're very often confronted with that. And it was curious, this idea that in 1946, for some strange reason, member states felt the need to create an Office of Legal Affairs. Mm-hmm. Now, as you said, I'm very proud that I have over 60 different nationalities in the Office of Legal Affairs, because I think working for the United Nations, we need to be multicultural, multilinguistic, and to have people from different legal cultures, which does not create any problem as such. It's very interesting, but I get to work with all these people coming from all over the world with different legal cultures. It's actually much easier than you imagine. There's something in common.
Common language?
Yeah, I think so. I think there is something of a legal mind, and so these different people work very well together. We tend to approach reality the same way, to ask the same questions, and it's actually interesting because it's complementary, people, all these different legal cultures. We cover many different areas. I would say the more political issues which are dealt by my office directly, Office of the Legal Counsel, and that would be more issues related to peace and security, peacekeeping, the more sexy topics in international law. And then we have a series of more specialized divisions, the law of the oceans and law of the sea division, that it's known when it's where we have a lot of expertise. They have a very close contact with the member states. They service different committees, they are, so to say, the guardians of UNCLOS and all related international instruments on oceans and law of the sea. Then the codification, that is, mostly, I usually say that it's our academics, so to say. They service the Sixth Committee, the International Law Commission. They prepare papers for members of the International Law Commission and for us as well. And then I have a small office in Vienna dealing with international trade law, which is also very specialized. Then the administrative law of the United Nations, because we have a lot of legal work related to the administration of the organization, which is a very large one. And lastly, a small treaty division which deals with deposits and registries. So it's very wide. It's very interesting. As I was telling you before we start, there's never a boring day in office, and it's a fascinating job.
No, it sounds it. I was struck by your comment about making room for international law.
Yeah.
I think we often feel the same way here at the Society, where we're also devoted to teaching about international law and trying to explain its role in world affairs. We had a conference last year, our annual meeting, that was devoted to the topic of the effectiveness of international law. Some people would probably put a question mark at the end of that phrase. And we devoted a lot of attention to that. I'd love to get your sense of whether international law has been effective in influencing state conduct. If so, in what way? And how can we measure that effectiveness?
Yeah, of course, I think it has been effective. Let me just add something on what we were saying, making room for international law. I think we international lawyers, we have a special responsibility, the way we build our relationship with the political decision maker. The way we work, it's very important to create this room. And I'm saying this because usually the relationship between lawyers and diplomats is not a love. It's mixed feelings there. So it's not a love marriage, it's more a convenience marriage, as we say in Europe. And we need to come to the table with ideas, suggestions. I don't, and I say this very often to my lawyers, we're not there to rubber stamp certain discussions or, if asked a specific question to make a beautiful opinion of 10 pages. We're there to try to help contributing to a solution, to explore alternatives, and it is with this attitude, being constructive, that we make room for international law. When our political decision masters understand that this is part of the discussion, and they will be better protected, covering this part of the discussion. So that's our special responsibility. Now, the effectiveness of international law. The first one, I would say, is an issue of perception. Every state claims to respect international law. That is already telling. Even North Korea claims to respect international law. I've never seen a state saying we don't care about international law. Or what they believe is, the international law solution. And this links still with the question, is international law really law? And because that question, I think, is influenced by the perception that there are no consequences coming from the infringement of international norms, and that's not entirely true neither. Think about sanctions, for instance. Those are specific consequences associated with the infringements to international law, and those can be effective vis-a-vis states, and not only states. Now the most modern generation of sanctions, individuals or groups of individuals, and I don't think there is a way of measuring this exactly, but we can ask ourselves how effectively were sanctions in the conclusion of the Iran negotiation process. Did they contribute something? I think most likely the answer is yes.
It depended to some extent on coercion.
Yeah, well, but that's again, the capacity of imposing certain unpleasant consequences on states, and this is not enforcement as we have in the internal legal order, but there are some measures of coercion to compel states to respect over international norms.
Yeah, absolutely. I wonder if I could ask you about a few of the issues that I think you undoubtedly have been working on. One would be the issue of refugees. Of course, we have the immediate crisis involving the Syrian conflict and the role of the United Nations in persuading countries to meet their obligations under international law, particularly the Convention on the Status of Refugees. What are your thoughts on how that can best be achieved?
Yeah, well, many different thoughts. And you are right in mentioning specifically the case of Syria, because that's one of the main causes of this huge refugee crisis, which is, I think, probably the most serious one since Second World War. We never had so many refugees in the world, and Syria is one of the main causes, and altogether one of the main causes of frustration nowadays for the United Nations and for the international community in general. First, let me say that this is often referred as a problem in the Mediterranean or European problem. I think this is truly an international problem, and part of the solution, or the most important part of the solution for that problem, is maybe in the Security Council. So it's many complex factors associated with this. When this discussion came up, the role of my office was to call attention to the international obligations already in place, for instance, in UNCLOS concerning rescue at sea.
Yes.
Because we didn't listen to anyone referring to those, and we were a bit alarmed, and we followed very closely the discussion of the Security Council resolution, which is a very original use of force to tackle the issue of smuggling of people through the Mediterranean. So we were a bit, preoccupied the way this would turn out, and we're still monitoring that very closely and reminding, that there are obligations already in place that we need to respect. Also, the Refugee Convention, which is not recognized by every state. Asian states usually have a problem with that convention. So far, our main role was just to monitor the situation and to remind that we already have some specific obligations that we need to respect. It's not solved yet. It's tragic. It has a very tragic dimension, and I think it's one of the main problems for the international community nowadays.
Well, and it may
apart from the images that we are all shocked to see, the little boy drowning by the Turkish coast, and this hasn't stopped. It's, as a European, I'm even more concerned, because I think this is a very important test to the European Union and to European cohesion, and I've been seeing things that I don't necessarily like as a European citizen.
And certainly things could get considerably worse when we look at the potential numbers of climate refugees who are being predicted, what they're calling environmental migrants. There have been estimates that by 2015 there'll be 150 to 300 million climate refugees.
Very good.
As a result.
I'm happy to see you not a climate change denialist. Because we still have those.
We do still have those.
We still have those, and the Paris Agreement, I think it was one of the big successes in the last years. A big successes for multilateralism, not for the United Nations, for member states, for the international community as such. It was a difficult agreement. It's very important to put it, in force, to really implement it, unless you are a climate change denialist. So, as someone said, getting the agreement in Paris was the easy part. Now we're getting to the difficult part. And in that respect, the United States position will be extremely important in the future. We have been following that closely as well. Everything which will happen here in Washington as well will have very important consequences. And I think the international community, and mainly the big member states, which have, of course, a leading role in this discussion, will be able to, start a constructive process that will avoid dealing with that situation.
I hope so. Yes. There's also obviously a link between the kinds of pressures that we're talking about, population pressures, climate pressures, and armed conflict. I know you deal a great deal with the law of armed conflict. And one of the things that is striking about the present moment is that armed conflict between traditional state adversaries has actually declined in recent years, but the prevalence of armed conflict among non-state actors or involving non-state actors has expanded to fill the space. I wonder what your thoughts are on, particularly given the difficulties in getting the Security Council to a point where they can deal with these challenges of non-state actor initiated armed conflicts. What do you think are the prospects for bringing any of this within the structure of international law?
I think what you've just said, it's probably the most interesting, but at the same time complex legal issues that we have been dealing lately in my office. It's issues concerning use of force by non-state actors, armed groups. As you said, we're outside, the classic framework of interstate war. We didn't have any interstate war in the past 10 years, not that I remember, did we? Quite frankly, the last situation I remember of involving states is the second Iraq invasion by the US. After that, I don't remember any situation. It's non-state actors, and especially in the context of terrorism, and that's the new threat, ISIS, Boko Haram, and so on. And since 2014, we had a lot of interesting situations concerning use of force against non-state actors, and I refer specifically to the actions being taken against ISIS in Syrian territory by a number of states, and these states invoking Article 51 of the Charter, self-defense, either individually or collective self-defense. And this has created a lot of very sophisticated discussions. We have to take in, we have about 9 situations, I think, right now. I'm looking at Steve Matthias. The US, France, UK, Germany, Australia, Turkey. I'm missing someone. And it's very interesting because they have all produced letters under Article 51 of the Charter. They're not exactly the same arguments and the same texts, but the type of questions that these groups raises are very interesting. You know, if you compare to what has been the traditional practice of interpreting Article 51, and then the type of questions that we have to examine, which is rereading the case law of the ICJ, and it's basically three important pieces: the world opinion, but also the Nicaragua case and Uganda, Congo armed activities, and rereading all these cases, establishing what they said, but mostly establishing or trying to establish what they didn't say, because that's also very important when you're examining case law, and then reading very carefully what type of arguments member states who are acting against ISIS in Syria are presenting under Article 51. This idea of the willing and able, this idea of the absence of effective control over the territory. As you can imagine, this is I mean, we can write books about it, and this is generating a lot of interest in most public sessions I've been lately. This question always arises. I was in Oxford last October also to have a conversation with students, and they only wanted to know about Syria and Yemen and Article 51 and use of force, and that's probably the most interesting question we have to debate nowadays.
Well, let me ask you also, this is closely connected with peacekeeping. And I know the United Nations is the principal peacekeeping entity that the world has for dealing with many conflicts around the globe. One issue that's arisen recently is how to hold UN peacekeepers accountable for criminal misconduct if they engage in it themselves. I imagine this is, again, an area that you are greatly involved in. And I wonder what measures you think can be implemented to prevent misconduct.
I've been lately. I've been quite involved in that discussion, and I'm glad you've raised that, because that's also a very sensitive topic we need to address very seriously. The United Nations and member states. I'm thinking about the situation that was reported last year, and that maybe most of you are aware of the sexual abuse in the Central African Republic against children, which was quite shocking when this news came into the public. This happened. I think the first half of 2014. Strictly speaking, it was not a peacekeeping yet. It was the French army before the establishment of a peacekeeping operation. But it doesn't matter. These cases were reported by a UN office in Bangui, and then there was at some stage a lot of criticism in the way the organization had handled these allegations and what measures we had taken to protect these children and to ensure some sort of accountability. And for this purpose, the Secretary General has called an independent expert panel to reassess, what had happened, if our reaction had been the appropriate one, and to suggest for the future how could we improve the system. This report came out last December. It came out with two very important observations. The first one is that in these kind of situations we needed to take more into account the victim's perspective, and second, that the organization being a very large organization, there was a fragmentation of responsibilities, that it was totally inadequate to react against situations like this. Now, I wanted also to start by saying that we have a lot of peacekeeping operation. I think 39 by now, or no, 16, 39 since the beginning of the United Nations, 16 right now, and this is, I think, 120,000 personnel, military personnel, and in very difficult situations. In Central African Republic, it's a very difficult situation. South Sudan is a very difficult situation. So every year, I mean, every day you have thousands of people serving with honor under the UN flag. But unfortunately, you have predators sometimes, you know, and we cannot deny it. The thing is, how do we react to that? We have discussed, and this is not the first time we have a crisis of this type. In 2003, there was also a big crisis concerning allegations of sexual abuse by peacekeepers, and that originated measures taken by the Secretary General, you know, on adopting strict guidelines on sexual exploitation and abuse. That originated the famous, I don't know if you heard about that, the Zaid report. Zaid is the current High Commissioner of Human Rights. In order to effectively fight against, you know, criminal conduct and in particular sexual exploitation and abuse, we need the United Nations and member states to have a perfect cooperation, because we don't have executive powers, we don't have criminal jurisdiction, we don't have prosecution powers. We rely on member states to exercise their criminal jurisdiction, to prosecute cases and so on. What we need to do is that we have to be very strict on the conditions under which we accept military contingents from member states. We have to have in place a lot of preventive measures, adequate vetting measures, and following on cases that are reported to national authorities. So we have to be demanding about the system, but we have to be aware. And you know, there's a lot of different measures. You know, this is a conversation also for an evening. The way I see this is to adequately fight against this problem. We need to have a creature with two legs: the leg of the United Nations, the leg of the member states, and we cannot have a creature with one leg. We need, you know, this structure to be in place with member states. And there is work to do on both sides.
Well, and in member countries as well, of course.
There's a lot of work. There's a lot of work, and I mean, quite frankly, I think part of this discussion sometimes is a bit hypocritical, because member states know very well that they're not doing enough, and then it's, you know, it's scapegoating the United Nations is easy. But and we need to improve the system, but we just cannot do it alone, you know. So I think we'll probably adopt stricter guidelines, for instance, naming and shaming member states who fail to adequately prosecute situations like these, which member states do not necessarily appreciate. And because when we try to have this discussion and, you know, said you need to be better, you need to do better, and then we come forward with certain proposals, and, you know, the reaction is also very negative. I don't think it's public yet, but you probably will read soon in the press that we're going to repatriate a whole contingent of 800 military personnel back to this country because of problems related to this. So, yeah. It's not an easy problem.
Not an easy problem.
Again, there's a lot of work to be done, but I don't want to have this discussion without reminding that every day a lot of people serve under the UN flag with a lot of honor, and a lot of people are killed, a lot of peacekeepers. This is also something that worries us. It's a cause of concern. It's a new phenomenon, this violence directed against not only peacekeepers but UN staff members. And for instance, Mali is the deadliest mission so far. I think about 50 members have been killed so far. So it's a new phenomenon. It's very disturbing, but
Well, while we're on the subject of accountability, I wonder if I could ask you a question regarding the crime of aggression. As most of our audience will know, there was a conference held in Kampala in 2010 that adopted amendments to the Rome Statute.
I was there.
I suspected you were. And this dealt with the jurisdiction of the International Criminal Court over the so-called crime of aggression. We just published the latest issue of the American Journal of International Law, which included an article by a current and former State Department legal advisor, Harold Coe,
Who was there?
who was there, and Todd Buchwald, his then colleague, who's still at the State Department, discussing some U.S. concerns about the activation of ICC jurisdiction in this area. I think what he said is that it could have a chilling effect on the willingness of states to use force to intervene in humanitarian situations. I wondered what your thoughts were on that. It's an easy question.
No, it's not. It's not, because I can cover, and I'm being recorded, so I cannot be as spontaneous as. I was there. Harold Coe was there with a big American team, which was interesting because for a non-state party, I think it was the biggest delegation in Kampala. And that shows that the US were very concerned about these negotiations. The compromise was I would say, almost a miracle, because it was 2 weeks of conference. I only attended the second week because I have experience, and I always know show up to the end, because when you have that 2-week conference, the first week is to...
Timing is everything.
Yeah. I mean, the compound was very nice. It was in Uganda. But the compromise was achieved like in the last hour of the last day. It was really amazing to be in the room and see. How can I phrase this in a diplomatic manner? I have been first. The amendment on the crime of aggression is not still, so it's a lot of conditions that have not yet been fulfilled, and I don't know if they will be fulfilled, because they're not that simple. Okay. From a strictly legal perspective and on the impact this will have, not necessarily for the reasons you have mentioned, I have been more convinced about the crime of aggression than I am today. This is already too bold to say when you record. I understand what the concern can be, especially for big countries with a big military power, which frequently are called to act on behalf of the international community. So I think we have to understand this. You mentioned something about humanitarian intervention. Yes, but only if authorized by the Security Council, because that's another big discussion.
Exactly.
Okay, and we have, I think, a very clear position on that in the Office of Legal Affairs. I do have. And this has recently been discussed about, because of the Syria, the issue of humanitarian assistance in Syria, and whether consent was required or not, and these links with the discussion, which is not a new discussion that happened in Kosovo, the right of humanitarian intervention, which I personally
to protect.
Yeah, but responsibility to protect is not a new norm. It doesn't give any right of intervention as such, beyond an authorization of the Security Council or consent by, the state. And this discussion came back again about Syria, and I think we have been strongly criticized by some press as being very conservative, meaning the Office of Legal Affairs. But yes, we have a conservative position on the question of humanitarian intervention. But to go back to the crime of aggression, we're following this, we're monitoring this closely. I understand the concerns, and I understand the concerns for a country like the United States of America.
But the good thing is they're still having the conversation.
Yeah, we'll see what happens. I'm curious to see what happens, but yeah, I mean, the conditions are not that easy to trigger the jurisdiction of the ICC. And I also, I mean, on a more general discussion, I'm also interested in, thinking about what could be the impact on the ICC, of the ICC having jurisdiction,
Right.
about aggression, about the crime of aggression.
In terms of its displacing other responsibilities?
Yeah, on the impact of its functioning, of its working load, its credibility, because when I'm a big supporter of international criminal justice. Okay, don't get me wrong, which goes beyond the ICC, at the tribunals. But I'm a very strong supporter of accountability. The thing is that international criminal justice is very new within international law. It's a young creature, it's an adolescent international law, and the ICC is a very new creation. So, it's still in the process of consolidating and making itself a place in the international arena. So, I wonder if that would be too much for the ICC right now. It's only 11 years right now, 10 years. And I think we need to think a little bit about that.
Let me ask you just a couple of additional questions, and I'd like to throw it open to our audience. As you know, there are a number of major United Nations treaties that have been awaiting U.S. ratification for many years. I wonder, sensitive to the politics of your giving an answer to this, what you think can be done either by United Nations entities or by Americans to try to persuade the U.S. and other governments to ratify these instruments?
I can't really say, because that would depend on which instrument we're talking about and what kind of objections, I actually made the research because I was coming here and I asked my treaty section to give me the exact figures of, for instance, the multilateral treaties. We have about 560 multilateral treaties which are deposited with the United Nations, with my office. And I think the United States has ratified about 110 and signed a few others that has not ratified. And then you have to see which ones and which ones were not ratified and why, UNCLOS, for the United Nations Convention on the Law of the Sea, has not been yet ratified, but at the same time we have statements by the State Department saying that the U.S. consider most of it customary law. And the same with the 1969 Convention on the Law of the Treaties, which is a very technical, I would say neutral convention. It has not been ratified, but I think there are also statements by the State Department in the same sense,
Yes.
Most of it is considered customary law. So in a way, I mean, they are effective. Now, at the same time, if you ask me, why is the United States the only country which has not ratified the Convention on the Rights of the Child, I don't know. I mean, I'm not familiar with the process enough, but I know that each year during the General Assembly, we have a small treaty event, which we organize, my office, and we invite states to come and deposit their ratifications or sign different conventions. And last September, Somalia came for the Convention on the Rights of the Child, and so the only remaining state is the U.S. Why is that? I don't know. So, but it's strange, isn't it? So we have to look into each convention and try to understand what is the discussion behind it. You have a complex legal system, so that's your constitutional system.
And even more complicated political system.
Exactly, but I leave that to the analysts of. I try to follow American politics, which is not entirely easy, and I read a few articles about who called it the vetocracy. It was Fukuyama or someone wrote an article about So I follow that on personal interest, but we should not also be too impressed by that. I'm saying that many of these instruments that have not been formally ratified are considered as customary law and respected as such. Whatever we say, the United States is a fundamental partner of the United Nations. It has a leading role in the United Nations, and that has not changed. And I don't think that will change in the next many years, I hope. So I don't think that affects the position of the United States as a leading or the leading member state of the United Nations.
Let me ask you one last question. And that is, what advice you would give to younger international lawyers and law students aspiring to a career in international law because they hope to make a difference in the world?
Okay. I would not formulate it like that, like to give advice. I tell you what catches my attention when I'm trying to recruit, and what I like to see when I read CVs of young people. I like to see people who have had different experiences, because that shows you already something. People who are curious to do different things. I encourage that it's good to show some diversity in your career. Obviously, speak foreign languages. And that applies mostly to young American lawyers, because you are in a comfort zone, but it's good to show that you speak other languages. I like lawyers who are creative, which is something strange because most people do not associate creativity with lawyers. That's wrong. It's for international lawyers is very important. We mentioned a few times Syria. And since I arrived in the Office of Legal Affairs, Syria has generated most of the interesting legal work we had lately. And it started with the whole process of the chemical weapons and the destruction of chemical weapons, and then the issues of humanitarian access. We didn't have any precedents in many of the problems we had to deal with, and what was required from the lawyers who have really worked on these was creativity, because they had nowhere to look to, so they had to come up with good solutions, and that requires creativity. So it's not usually something we require from lawyers, but it's very important in international law.
Thank you very much. Let's go to audience questions. I'd like to invite you to ask a question. Please don't give a statement, just so that we have ample time for everybody to speak. But if you would keep your questions brief, just please identify yourself and your affiliation. Now, do we have a microphone?
We do.
Great. So please wait for the mic so that we get everything you say on tape and can hold it against you later.
or against me.
So the first question.
Thank you very much for your time, sir. My name is Christopher Monger, and full disclosure, I spent some time at the UN in the division of the UN Office of Drugs and Crime, Terrorism Prevention branch in Vienna under John Sandwig. So, a real chance to do international law there. Some of the sexier issues you talked about. You had spoke briefly about the right to protect, and I asked this question because it spoke to a lot of what we talked about working in the international sphere, working with coercion, working with some of those ideas. We have some people in the United States now, obviously, most famously Ambassador Power and Hillary Clinton, who have used R2P either explicitly or non-explicitly to intervene. The office that you work in has a very conservative idea. Do you see it as a growth potential just by state action, or do you think that there's still going to be some dispute about whether there is a chance to grow or a chance to use it as a vehicle to carry out things like the genocide convention, prevention of genocide? What's your view as a legal theory, and then is there a future for it? Obviously, I know you can't recording, so you can't have you go too far off script.
No, but I can give you quite some time. I don't feel uncomfortable with the question, and do not worry about the questions because I always have the choice of not answering. So as we say in my own language, they are not difficult questions; they are only difficult answers. But actually, your question, you touched upon many different aspects. Responsibility to protect as such is not that. It's true that we have not listened lately very much about responsibility to protect, and because it's something that was, I think, probably put into test because of Syria, and Syria has failed so tragically, we're not talking about it. But it's not that. It's not that as a method. Responsibility to protect is not about the creation of new norms. Is about a general method of dealing with situations like we see in Syria, and mobilizing tools that are not exclusively legal, are also and mostly political and diplomatic. But you mentioned also, in connection with this discussion, humanitarian intervention, which is different, and we often look at the problems like they entirely new. This discussion has happened with a lot of intensity about Kosovo, if you remember, and even within the United Nations, Kosovo was a very good situation where you had this so-called split between the traditionalists who see, the charter as including all the tools to deal with this type of situations, and the so-called modernists that needed, And there was this famous speech by the then Secretary General Kofi Annan about if you remember, the illegal but legitimate, the Switchley speech. It doesn't matter, but it's a very famous speech. There's a very good book about this, which was written by the then Assistant Secretary General Rolf Zeckling, and it tells about the internal discussions in the United Nations about this. These type of situations are very shocking, but we have to be very careful in protecting the legal tools we have and protecting the charter, because that's all we have right now. So I hope that in the next 20 years, international law will be improved and will be better equipped to deal as situations as what we see in Syria. But right now we're not there. There's not a right of intervention, outside a Security Council authorization or consent by state. Thank you. You referred also Ambassador Power.
That's correct.
Yeah.
She is most explicitly
advocated something along those lines.
Because it's so, she has she's a wonderful ambassador in the United Nations. I think we all like her, even if we don't agree all the time.
Oh, of course.
She's very passionate about this. She wrote the wonderful book about genocide, and I mean it's very difficult not to be sensitive in this discussion and to feel frustrated when the international community is not able to react to this type of situations and put an end to this immense suffering. And then we have to go back to the Security Council and the limits of our international system and ask ourselves the question, I mean, if the international system, which is the only one we have, is not capable of dealing adequately with these situations, it also opens in a certain way a crisis on the legitimacy of our international governance bodies.
Next question.
Yes. I'm wondering if you see any.
Give us your name and.
Elizabeth Wilson. I'm just about to join Rutgers Law School. I am wondering whether you see any potential in trying to reformulate the rules that might apply in a situation that we have been referring to as non-international armed conflicts, where there isn't really a distinction made between violent protest movements and nonviolent protest movements, and in the case of Syria and Libya, there was quite a distinction. In Libya, there was not a very sustained nonviolent protest movement. It turned quickly to violence and may have provoked even the harsh response from Colonel Gaddafi, whereas in Syria, there was a very, very sustained and creative nonviolent movement. And should we be working towards trying to create as a kind of international legal framework to deal with large-scale nonviolent protests, perhaps seeing them as akin to civil wars in some ways, or manifestations that show that the breakdown of effective control has in fact happened. And
yeah. You know, when we were mentioning in the conversation the fact that wars are not happening the same way as before, it's more or less related to that question formulated in less technical terms. What you have now in terms of these eruptions of violence with serious consequences, atrocity crimes and so on, is outside, or it's new in a framework which was designed a few decades ago with something else in mind. So I think we need to keep this debate going on, because maybe the current legal framework is not entirely prepared to deal with the new threats and the new situations we have to face. Without going into much technicalities, because in a conversation like this, you know, it's very difficult, and I don't want to sound too light in that. I want to give you an example. The Secretary General has referred lately that starvation as a war weapon is a war crime, and he of course had in mind especially the situation or the situations in Syria. And you know that as such, this statement legally is very controversial, you know, the international or non-international armed conflict. But there's something we cannot deny, is that starvation is being used as a war weapon. So, although I was entirely supportive of this statement, because, you know, I think it's time to maybe start favoring a progressive interpretation of certain aspects of international humanitarian law, this is still controversial. So I think that's proof that we need to feed that debate, and we need to start thinking about these topics.
Hello, good evening. Thank you, sir. My name is Benedicta. I'm a Georgetown Law student. I know you were there today, but I had class, unfortunately. My question is that how often does once you're talking, I was thinking about the Boko Haram invasion of Nigeria and kidnapping of the Chibok girls. Has your office had any, what is your office doing in that regard? I know that maybe out of your reach, maybe another office's work to do, but what is your office doing anything in that regard? Thank you.
In regard to Boko Haram specifically?
No, in regards to the Chibok girls that were kidnapped.
To the kidnapping of the, yeah.
Yes.
I mean, not directly. Unfortunately, I would love, give me a gun, I'll go there and help to free this girl. But we are a legal office, we're not operational. I don't have soldiers to help me, you know. Yeah, I mean, it's a tragic situation, it's really horrible. You know, but as the Office of Legal Affairs, I wish we could have some operational go there and help to solve the problem.
Good night. My name is Hugo Cagüeñas. I'm from Ecuador. Actually, I'm doing an LLM in George Washington University. I have a question about soft law.
I hate that word.
But you refer about some guidelines. Sometimes you refer to treaties. Recent developments in international law are in soft law instruments. In fact, some of the agencies, UN agencies, have developed guidelines, principles, rules. But what is the real effect of those instruments? How do your office employ these instruments on your legal analysis, and which is your personal opinion about it?
Okay, on a very philosophical approach, I don't like the concept of soft law. And I don't like, I mean, there is law out of soft, you know. And you have to understand, for a continental lawyer, it's even more difficult than from a common law lawyer to work with this distinction between soft law and hard law. There are norms, and they are either legal or not, okay? So we are aware of this proliferation of what you call soft law, guidelines, whatever. And we have to work in order to identify if they're really norms, I mean separate legal rules which are applicable and so on. In our daily work, maybe we will have to consider all the different provisions connected to a topic, but I have already this philosophical impediment, you know, to treat soft law. I mean, there's something different from law, you know. Ecuador is also mostly a continental system, no?
Yeah, civil law.
Civil law system, yeah.
Yeah.
So you understand my difficulty? Or,
Well, but here we have the concept of lex ferenda.
Yeah.
What it's supposed to be, so and how do you fit this with it?
You know, but that creates also, I mean, it has political repercussions, okay? For me, law and international law is something that at some stage has to have, you know, clear consent by member states, most of the times expressed in a parliament, you know. So international law needs to be adopted as such, you know, through a political decision. So you see the danger of that discussion, that norms are being created outside the democratic control of states.
Thank you. My name is Jean Nguyen, and I'm with Voice of Vietnamese Americans. So I have one question in three different aspects regarding the rules of law. How do the UN, under your council, uphold the law? For states who have already signed on to that treaty, how do you keep them to their signatory to be accountable to what they signed on to. For example, the UNCLOS, United Nations Conventions on the Law of the Sea, China signed on to it, and recently there's a case, the ICG. How do you keep the law enforced if China doesn't want to obey it? And the same apply for human rights. Like in the case of China, there are many cases that it violate human rights of the Chinese people itself very horrifically, like it even harvest organs or so. And also in the case of Vietnam, they signed on to the UN Convention on of the torture, non-torture, but they kept torturing people. And recently, within the last few months, there are many prisons, not even prison, there are many people being detained in the police office, and they being tortured to death after that, within a day or two. So how do the UN steps in and help? I know that recently the people in Vietnam have very high regard for the UN. They look up to you. And they thought the law is the top and everybody has to obey it, and they're trying to live up to it. But somehow the reality isn't what they expect. How do we keep the trust of the people in the law?
Thank you for the question.
Thank you.
Many questions.
Just one, how do you enforce the law?
Okay, no, I'm not an enforcer. I wish I would be an enforcer. I'm not. We member states are the enforcers. Okay, I don't know exactly to which case you were referred in the International Court of Justice involving China. Okay, yeah, but that's different. That's arbitration, and the jurisdiction is not accepted. There's a lot of issues, of course, in South China Sea, not only Vietnam and China, but other countries in the region. What we do, we encourage, and that's our mission in the Secretariat, because the United Nations is very big, okay? I encourage, the Secretary General encourages, as it is our duty, the peaceful settlement of disputes. And that includes jurisdictional solutions, but before that, all the means, mediation, good offices, and so we encourage and we keep encourage diplomatic solutions and jurisdictional solutions to conflicts. That's what we can do without enforcement powers. So I hope that this issue will come to a good result in the end, but that's what I can tell you. Plus, I'm not the International Court of Justice, so it's not for me to declare infringements to international norms or not. I may be advised to ask on a non-public manner the Secretary General on my assessment of a certain situation, but that's in my capacity of the legal advisor to the Secretary General. And he does not necessarily will want to communicate on that, because that's maybe incompatible with the need to pursue diplomatic solutions. A lot of the SG has a lot of preventive work, preventive diplomacy work, and silent, quiet diplomacy, what we call quiet diplomacy, which sometimes is welcome and sometimes is not entirely welcome, but that's part of the job.
Question?
Just to finish and before you start, what we encourage very strongly is acceptance of the compulsory jurisdiction of the International Court of Justice, which unfortunately not as many states as we would like have accepted. I think 65 or 66 by now, which is clearly not enough. And it's very frustrating because out of the 5 permanent members of the Security Council, which, they have special responsibilities, only 1 accepts the compulsory jurisdiction of the International Court of Justice, and that's the United Kingdom.
Thank you. I'm Tim Schnabel. I'm from the Legal Advisor's Office at the State Department here. I was hoping to ask for your thoughts on sort of the road ahead on the private international law side of things.
On the?
Private international law side, not just so UNCITRAL, but also more broadly the other organizations that do work in that area. Member states spend a lot of time on international law in that area. The organizations spend a lot of resources on it, and there is, oftentimes progress. Even here yesterday, the president sent 3 UNCITRAL treaties to our Senate for advice and consent. But at the same time, there are a lot of instruments from these organizations that tend to sit on the shelf that states may not use that often. How do we, when looking at the years ahead, try to calibrate the work that we do in these areas so that we don't churn out instruments that aren't used, but that we shape the law in ways that states actually have an appetite to adopt?
Yeah. I'm not sure I know how to answer your question, because I'm only familiar with a small part of the private international law, which is international trade law. So I'm not very familiar with the Hague Conference on Private International Law and other UNITRA and other fora where private international law is being harmonized or discussed. So for what I see of trade law, which is part of my office, is a very strong interaction with member states. I mean, member states are the most direct clients of that product. And what I see being discussed, I see being more or less immediately adopted by member states. So this probably shows that there is a practical need of that instrument. And I think it was one of the last instruments that the US has signed. It was the Transparency on Arbitration Procedures, which was prepared within the scope of UNCITRAL. And so if there is this quick reaction to these instruments, it's because the practical need was there, That would be my general comment. Being unfamiliar with the work being done in The Hague and Rome on the harmonization. I mean, I did quite a lot of private international law, but it was 20 years ago. So I'm a bit outside that game. Sorry.
Questions in front? Hi, I'm Anna Katselis. I'm at the Environment Division of the U.S. Department of Justice. I have what hopefully will be a fun question. As a lawyer who sometimes wishes my work was more creative, I wanted to pick up on your mention of that and ask what you meant about why it's valuable in the work that you do and your team does. And I imagine you mean in the negotiation of treaties. But if it's something else, I'm interested to just hear more about it.
Yeah.
And also, if you could cite a couple of examples of creative lawyering, that maybe a compromise came out of it or something like that. I think that would be interesting to hear.
Okay. I mentioned one of the examples, but I'm going to give you a little bit more detail. There was Syria and the destruction of chemical weapons. Okay. And actually, this was interesting because it was the first time that we did a joint mission with the OPCW, the Organization of Prohibition of Chemical Weapons. And if you remember our involvement, there was first this Sellstrom report that the Secretary General has called after allegations that chemical weapons were being used in Syria, which is something we have not seen since Saddam Hussein in the old times. And then the Sellstrom report established, yes, chemical weapons had been used, and we did this joint venture with OPCW to go in the territory and identify and transport and destroy eventually the chemical weapon stocks. Now, this is a very dangerous environment. Going into the Syrian territory, and it's new in the sense that we needed to establish agreements between the different institutions, and there was no precedent. There was never a mission like this on a very difficult environment covering, insurance aspects. I mean, the whole operation aspects were very complicated. Some of these chemical substances were destroyed in the sea, on the sea. So you had to conceive of the operation of the maritime transport, where what was the port of call, and then at some stage we had to prepare the legal instruments with the state which flagged the ship carrying the substances was being used, and then there was a transfer operation in the sea from one navy to another navy of a different naval force, and trying to imagine all possible aspects that needed to be addressed and coming up with a solution that required a lot of creativity, because there was nothing in the past to, A second example was UNMIR. UNMIR was the mission established because of Ebola, and it was like a health-keeping mission, so to say. And it was the first time that the United Nations created a mission in a health emergency. And as you can imagine, there were no precedents, so you had to look into what is the risk and the situation we need to address, and what are the different aspects we need to cover. You had to draft agreements with the 3 governments involved, and agreements governing the sending staff member there and non-staff member, and addressing all different aspects on a very risky operation. And actually we spent a lot of time in the United Nations flogging ourselves, and that horrible things happen all the time, that was a success case. I should have to, that was something that has worked very well, because Ebola is controlled right now, and that was something where the legal component was very important. And when I say creativity, I think of this capacity to look into a new problem you are unfamiliar with. You cannot look into the past because there's not a similar experience. And you have to think about new solutions, how to address this new problem. That's what I meant by creativity. And that some people have and some people don't. But we need all types of people in the world, right?
We do. I think we have time for one final question. Gentleman in the back.
Hello, my name is Bill Flanagan, and I'm the Dean of Law at Queen's University in Canada. And about 2 years ago, I had the opportunity to visit Jerusalem and met with the legal staff at UNRWA, and they gave me a briefing of the international law relating to the conflict in the Middle East. And I also had an opportunity to tour the wall with a UN human rights monitor. And by the way, the staff was really outstanding. The legal staff was of first class. But I was struck by the complexity of the international law governing this conflict, and yet the extent to which the international law had not really been effective in restraining the conduct of the parties. And so, easy question here, what is the role of the international law in this ongoing conflict and in resolving this conflict?
If I knew the answer, for that answer and any questions related to that issue, I would be probably a candidate to the Nobel Peace Prize. I don't know. I don't even know how to start answering that question. I'm going to Israel in 2 weeks' time. I'm very curious to see the country, address the situation, and with the possibility of maybe exchanging with some Israeli colleagues about those topics. I will put them your question to them.
Well, thank you. Thank you all.
And this is very clearly avoiding an answer.
You did it so well, we didn't even notice. I just want to express appreciation to a number of people for making this evening possible. Most particularly to Steve Mathias, who is the Assistant Secretary General for Legal Affairs and a great friend of the American Society.
And a member of the...
And a member and a supporter. And Marcus Pellick of the Office of Legal Affairs. I want to thank Wes Rist and Julia Knox of our own Department of Education and Research, and our fellows who helped put all of this together. It's been a tremendous pleasure having you with us.
My
I hope
pleasure.
this will only be the first of many visits.
Sure.
And I hope you will also all join the Undersecretary General for reception immediately following the program. I'm sure he'd be delighted to meet with you. And finally, please join me in thanking him for being with us today.